Yeah, just
all the speakers come up.
and I'm gonna grab a few chairs,
Okay.
and so that way you can sit down and rest a little bit.
Okay.
Do you need water?
No, I'm fine, thanks.
Okay, great. All right, I still see a couple of seats down at the front, so let's fill those up, and we'll get started. A couple of quick announcements to make, and these are kind of fun mystery announcements. There's a missing blue Contigo water bottle that someone is looking for. I don't know if anyone's seen it. If you do see a tall blue Contigo water bottle, bring it down to the front, and hopefully it can be returned to its owner. There's also a book on the Valley of Vision, the collection of Puritan prayers. Someone had that reserved at the book table. They've not shown up to grab the book. So if that's you, then speak with Pastor Byron Snap out at the book table right away. So hopefully our mysteries can be resolved. We'll welcome again Colonel John Eidsmoe. Take it away. Very good.
Well, good evening. Wonderful supper up there tonight, and the clothespinning that I got, that was fun. But somebody should have taken a count, I don't know. But anyway, tonight we're going to be talking about curbing government power, or checks on government power. But before we get into that, we need to talk about why we believe checks on government power are necessary and why our founding fathers thought they were necessary. You know, the framers of the French Revolution wouldn't have thought that at all. They had a revolution there that they based on a belief in human goodness, or that man was perfectible, and essentially the Marxist view. They took a harlot and placed her on a throne in the Notre Dame Cathedral and crowned her as the goddess of reason, which was the new religion that they were promoting for humanity. With this belief in human goodness, they saw no need for checks on government power, and so they took over as a group of self-appointed thugs, not as people that had any legitimate claim to power at all. They claimed to liberate the Bastille, where all the political prisoners were. There were actually 6 prisoners in the whole prison, and none of them were political prisoners. The only one who was a political prisoner was the Marquis de Sade, and he had been released earlier. They then proceeded to engage in a reign of terror in which they exterminated all the aristocrats, and when they ran out of aristocrats to exterminate, they started exterminating each other, which I argue was the only good thing they ever did. And it finally took the dictatorship of Napoleon to restore order, and France really hasn't fully recovered since. But our founding fathers didn't buy into any kind of nonsense like that, because they came out of primarily a biblical and Christian worldview. And we might ask this question. You've probably heard this term, Christian nationalism. And that's a scare word that's being thrown around today. Anybody who thinks that God has anything to do with government is a Christian nationalist. Hey, the best way to handle an accusation of Christian nationalism is to ask, what do you mean by that? And usually they have no idea, just some phrase they've heard somewhere. Or if they do, well, what it means is Christianity is the official religion of this country, and nobody who isn't a Christian has any business here at all, or if they do, they're second-class citizens. To which my response is, okay, if that's what you mean by Christian nationalism, I now understand you. But I don't believe that, and I've been involved in the Christian right now for 50-some years, and I don't know anybody who does. So where are you getting all this? It comes down to partly the question, what do you mean by a Christian nation? And if you mean one of those things, that Christianity is the official religion, or the only religion, or the enforced religion, then no, we are not a Christian nation, and I don't believe we should be. But if, on the other hand, you believe that A Christian nation is a nation that was founded primarily by Christians who built a culture and a system of government that was based upon the Bible. If in that sense you're talking about a Christian nation, then yes, America was founded as a Christian nation and to some extent remains a Christian nation today. But let's just look for a little bit at the founding of America. And one of the things you'll hear people say regularly is that those founding fathers, they were deists. I just had somebody say that at a hearing before the Alabama legislature a short time ago, and fortunately I was the speaker coming after her and was in a very good position to refute that. But if somebody comes home from college and is saying to you and some of your friends, Jefferson and Washington and all those dudes, they were deists, they weren't Christians. If your response is, well, what's a deist? You're probably not going to get very far. So, first of all, what is a deist? What does that term deist mean? Anybody know? Anybody offer? Go ahead, sir.
A deist is someone who believes that God made the universe like clockwork and then
Okay, that God made the universe by clockwork. If I were teaching a class right now, you'd get an A+. Excellent answer. That God created the universe. He established natural laws and moral laws by which the universe operates, but then he somehow retreated from the universe and he went off into another galaxy somewhere, or maybe he went down to Argentina and lives in hiding down in Argentina or something, but he is not actively involved with human affairs anymore. If that's the definition of deist, and it is the most common definition, then I would say that none of the leading founding fathers of this nation were deists. There were a few people who were deists. Ethan Allen of Vermont probably was a deist. Thomas Paine may have become a deist later, although if you read through his pamphlet, Common Sense, he bases the claim for American independence squarely upon the Old Testament. Now, if he does that, you've got to reach one or two conclusions. Either at that time, Paine believed in the Bible, and then by 1800, when he wrote The Age of Reason, he did not, or he didn't believe the Bible at that time, but he knew that he had to make the case for independence based on the Bible, or the American people wouldn't listen to him. That certainly tells you that regardless of what Paine believed, the American populace at that time was Christian. But when I assert that the founding fathers were mostly Christian, and by the way, I did a great deal of research on that and produced a book, Christianity and the Constitution, I'll make three basic lines of approach to that. First of all, church membership. Now, granted, church membership doesn't always indicate what you believe. Some people believe to a church and don't really believe the teachings of the church, but as I was speaking to the Master's College some time ago out there with John MacArthur School, I just said there, well, if you were to tell me that somebody belonged to Grace Community Church, I'd probably assume that he believed this, 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 and this, and possibly not, but at least that'd be a pretty good presumption. The fact that out of these 55 delegates to the Constitutional Convention, the overwhelming majority belonged to Christian churches says something about where their religious beliefs lay. Out of those 55, 28 of them belonged to the Church of England, which at that time was an Orthodox church. 8 of them were Presbyterians. I think that was PCA, if I recall. I'm not sure about that. No, obviously not. But they were the fiery Calvinists of the day. There were, I believe, 7 Congregationalists. Those were your New Englanders, Puritans, but possibly some might have had a few Unitarian leadings. There were 2 who were Dutch Reformed, 2 were Lutheran. I think that's our South Dakota delegation, although I kind of doubt that they made it. There were 2 Methodists. There were 2 Roman Catholics. There's one, McClurg of Virginia, that we don't know what he believed. There isn't enough written about him. He was buried in an Episcopal churchyard, indicating probable church membership, but we'll just say uncertain. And that leaves 3 out of 55 that you might say were unorthodox in their beliefs. Franklin, for example, and even people like Franklin, I would say were probably Unitarian, but definitely not deist. But let's look at some of the leading founding fathers, and I know Dr. Schultz has talked about this already. And by the way, the first time Dr. Schultz and I met was back in the 1970s when I was at the Lutheran Brethren Seminary in Fergus Falls, and he was at Oak Hills Bible College in Bemidji? And anyway, so we've had a long history together, and certainly good to be here at this conference together with Dr. Schultz here today. But he's talked about Dr. Witherspoon, for example, and I would consider him possibly the nation's leading authority on Dr. Witherspoon today. So I'll pass over Witherspoon, except to say that clearly he was a Christian. And we can talk about founding fathers. Witherspoon could be described as the founding grandfather. In other words, the founding fathers learned from him. But let's just look at a few others for a moment. George Washington, for example. Now, Washington was not outspoken about his beliefs, but he was faithful in church attendance, and if he had people visiting at his home, he would bring them to church with him if they were willing to come. And he, on numerous occasions, would affirm his belief in the divinity of Jesus Christ. For example, when he retired as general of the army, intending to go back and make an honest living as a farmer, he sent a letter to the 13 governors in which he referred to Jesus Christ as the divine author of our blessed religion. And the historian Henry Cabot Lodge says of that statement, either Washington believed in the divinity of Christ, or when he wrote those words, he deliberately stated something he did not believe. Washington was a vestryman in the Episcopal Church. Now, to take office as a vestryman, he signed a sworn oath saying he accepted the doctrine of the Episcopal Church or the Church of England, and that doctrine would include the inspiration and authority of the Scriptures, the divine and human natures of Christ, the Trinity, substitutionary atonement, justification by grace through faith, and at that time, the 39 Articles of Calvinism. If Washington did not believe those things, he committed perjury when he signed that oath. One thing that is often said to indicate that Washington was not orthodox in his beliefs, you'll hear the claim that Washington did not take communion. Excellent book on the subject by Peter Lillebach, the president of Westminster Seminary, and Jerry Newcomb of Coral Ridge Ministries, titled George Washington's Sacred Fire. And I think they demonstrate the fallacy of that reasoning quite well. They point out that Washington was in the Church of England. Now, to take communion in the Church of England, you need to be in good standing in the Church of England. Who is the head of the Church of England? The King of England. Washington is leading a war for independence against the king. So he can't very well claim he is in good standing with the Church of England. Now, he took communion in the Church of England before the war. He took communion in other churches during the war, and he took communion in the Church of England after the war. Somebody who was less sincere about his beliefs probably wouldn't have let those details bother him, but Washington did. Let's go on to Alexander Hamilton. Hamilton, fascinating man, but I could talk so much about his background, but I've got so many other things that we need to cover tonight. I'll just simply say that shortly before Hamilton died, he laid plans to establish a society that he said would promote the principles this nation needed. And he wanted to call it the Christian Constitutional Society. He didn't call it Americans United for Separation of Church and State. But of course, his life was cut short by a duel with Aaron Burr, and Hamilton personally was opposed to dueling, even more so afterward. But he was so opposed to dueling, in fact, that he determined he had only one course of action available, and that was to face Burr in the duel and refuse to shoot back. And that wasn't all that uncommon a practice then. And so he wrote a letter to his wife the night before the duel, in which he said, "The scruples of a Christian have determined me to expose my own life to any extent, rather than subject myself to the guilt of taking another. This much increases my hazards and redoubles my pangs for you. But you would rather I should die innocent than live guilty. Heaven can preserve me, and I humbly hope will. But in the contrary event, I charge you to remember that you are a Christian. God's will be done. The will of a merciful God must be good. Once more, adieu, my darling, darling wife, Alexander Hamilton." The duel took place. Burr fired first and struck Hamilton. Hamilton's pistol fired. It may have just been a reflexive clenching of the trigger, but the shot went wild. He lingered for some 31 hours. Before he died, he took communion. And in taking communion, he said, "I have a tender reliance on the mercy of the Almighty through the merits of the Lord Jesus Christ." One of my favorites of the Founding Fathers would have to be John Jay. John Jay was famous for the signing of Jay's Treaty, and famous also as one of the three authors of the Federalist Papers, but also first Chief Justice of the United States Supreme Court. But I think he will go down in the annals of eternity primarily as a founder and national president of the American Bible Society. And here's one of the addresses he gave to the American Bible Society, and as you listen to this, just consider the correctness and the orthodoxy of his doctrine. He talks about the need to share the Bible with the world because a great proportion of mankind are ignorant of the revealed will of God. And he says, by conveying the Bible to people thus circumstanced, we do them an act of kindness. We enable them to learn that man was originally created and placed in a state of happiness, but becoming disobedient, was subjected to the degradation and evils which he and his posterity have since experienced. The Bible will also inform them that our gracious Creator has provided for us a Redeemer, in whom all the nations of the earth should be blessed, that this Redeemer has made atonement for the sins of the whole world, and thereby reconciling the divine justice with the divine mercy, has opened a way for our redemption and salvation, and that these benefits are the free gift and grace of God, not of our deserving, nor in our power to deserve. That is about as orthodox as you can get. He served for a while as an ambassador to France, and he described his experience with the French revolutionaries, the deists and philosophes over there. And he said, "During my residence there, I do not recollect to have had more than 2 conversations with atheists about their tenets. I was at a large party at which were several of that description. They spoke freely and contemptuously of religion. In the course of it, one of them asked me if I believed in Christ. I answered that I did and that I thanked God that I did. Nothing further passed between them and me or any of them on that subject." There's many more of the Founding Fathers that I would like to talk about, but we need to move on. But somebody asked me earlier today about Patrick Henry. And so I'm going to have to say a few words about Patrick Henry. And one of the things I told her was that a few months ago, I married Heather Henry, who was a direct descendant of Patrick Henry. What I mean to say by that is I performed the ceremony for her and her fiancé. I did not marry Heather Henry, but Patrick Henry, probably the most respected man in America at that time, outside of Washington himself, was an outspoken Christian. On one occasion, he wrote to his daughter, "Among other strange things said of me, I hear it is said by the deists that I am one of their number, and indeed that some good people think I am no Christian. This thought gives me much more pain than the charge of Tory, because I think religion of infinitely higher importance than politics, and I find much cause to reproach myself if I have lived so long and have given no decided and public proofs of my being a Christian. But indeed, my dear child, this is a character which I prize far above all that this world has or can boast. As a young lawyer, Patrick Henry was traveling in rural Virginia on his way to Spotsylvania County's courthouse to defend a client there. And when he came into the courtroom, he found that there were several Baptist preachers who were there charged with preaching without having license from the Church of England to do so. Henry listened for a moment, and then he stood up and said, "Excuse me, Your Honor, what did I hear? Do I understand that these men are being charged for having preached the gospel of the Son of God?" And when informed that that was essentially what was happening, he asked to join the defense. Well, they lost their case because the law was simply against them on it, but he paid their fines for them and said, "If you get in trouble again, come to me and we'll do the same thing." But that gives you a little picture of the Founding Fathers, and those are only a few. If we had time, I could talk about so many more, but what you might say characterizes the Founding Fathers would be, number one, a high view of God and His law, that there is a higher law than man's law to which all human law must conform. The Declaration of Independence simply puts it this way: the laws of nature and of nature's God. But the second would be a low view of man and his nature. They believed essentially what the Bible teaches and what Christianity teaches, that man is a sinner, that man is separated from God, that man is infected with original sin, and that has a couple of political implications. First of all, it means that people cannot live in a state of anarchy. They will abuse each other in a state of anarchy, and they will rob and kill and assault and kidnap each other, and nobody will be free. And so we need government. But the other implication of this is that those who run the government have the same sinful nature as everybody else. You might say, in other words, that this doctrine of total depravity that Calvinists and Lutherans believe in is a great leveler. And that being the case, we can't trust people in government with too much power. So the problem that the Founding Fathers faced at that convention there in 1787 was this: how do we give government enough power to govern effectively, but at the same time restrain that power so it does not become tyrannical and oppressive? And the way they do this is what I describe as, my seminary professors would have loved this. They kept trying to teach me alliteration. The Founding Fathers' fivefold formula for freedom. That sounds great, except alliteration is almost always absolutely awful. But I did say almost. But what about that fivefold formula for freedom? First part of the formula, government of limited and delegated powers. That is, government has only the power that we, the people, have delegated to it through the Constitution, and no others. And as the 10th Amendment makes clear, the powers that we have not delegated to the federal government or prohibited to the states are reserved to the states respectively or to the people. This is a cornerstone of freedom. It means if some federal official comes here and tries to do something and says, "Show me where the Constitution says I can't do that," he's got it all turned around. He has to show where the Constitution says he can't or he can do it, or else he doesn't have that authority. Second part of the formula is separation of powers. We have separated the powers of government vertically into federal, state, and local government, and we have separated it horizontally into legislative, executive, and judicial branches. So no one level, no one branch, no one agency, no one individual gets too much power. Third part of the system relates closely to the checks and balances, or to the separation of powers, and that is checks and balances. These three branches of government are not just strictly independent of each other. If they were, we'd be governed by a three-headed monster instead of a one-headed monster. Instead, there are checks and balances written into the Constitution so that each branch of government and also levels of government check the powers of the other. And sometimes they do so not with an altruistic motive in mind. Sometimes they do it to preserve their own power. Congress passes laws. The president can veto those laws. That's a check. To balance that, Congress has the power to overrule the president's veto by a 2/3 vote of each House of Congress. And then we have the Supreme Court. The Supreme Court has the power, arguably, and there could be debate on this, but arguably, at least, the Supreme Court has the power to strike laws and actions of the president down as unconstitutional. But there are also some checks on the court, and I'm going to save that for just a little bit. We'll see what checks are available, because of all the branches of government, it seems today like the one that is most unrestrained today is the judicial branch of the Supreme Court, and we'll see a little reason why that happens to be the case. So, we've seen limited delegated powers, separation of powers, checks and balances, reserved individual rights. By that, what I mean is that the framers did not create a system of absolute, unfettered democracy in which the majority gets to do whatever it wants. Rather, they recognize that that can be tyranny of the majority over the minority. And so they established a system in which the majority generally runs things, but the minority has certain rights that even the majority cannot take away. For example, your right of free speech. If the federal government were to say that this worldview conference, we got to put these to an end because they're inviting all these flaky speakers from Alabama who speak about the Constitution and stuff like that, and so we need to take this and maybe even take Milligan University and make it into a special museum for the People's Republic of America. If the Supreme Court is doing its job properly, it will strike that law down as unconstitutional, even if that's what the majority of the people want. Because, as I say, the majority generally runs things, but the minority has certain rights that even the majority cannot take away. And finally, responsibility through religion. Now, the framers didn't want a state church, neither do I. I certainly wouldn't want Joe Biden or Hillary Clinton running the church, and I really don't think I want Donald Trump running the church either. But nevertheless, religion does play a civil role in society. Besides the role that it plays in saving souls for eternity, religion also, and when the framers spoke about religion, they used the term pretty much interchangeably with Christianity, but it also creates the kind of moral character in people that makes responsible self-government possible. Washington put it so well in his farewell address: of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. And then he went on to say, and let us, with caution, indulge the supposition that morality can be maintained without religion. Whatever may be conceded to the influence of refined education on minds of peculiar structure, reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle. John Adams, our second president, who I might argue was possibly the most scholarly man ever to sit in the White House, including Jefferson, although Jefferson would come close, but he said, our Constitution was made only for a moral and religious people. It is wholly inadequate for the government of any other. So, responsibility through religion. It is religion that produces the kind of character in people that makes responsible Republican self-government possible. Having said this, let's talk a little bit about checks that are written into our Constitution in general. I'm just going to mention a few. One of them we have for the president. We have a two-term limit on the power of the president, recognizing that the longer a president serves, the more powerful he becomes and the more difficult it might be to unseat him. The delegates at the convention at first voted to have a two-term limit on the president, but they noted that Washington seemed to oppose that. And so when it came to the final draft of the Constitution, that was eliminated, and so there were no term limits at that time. However, after serving 2 terms, Washington said that he thought that was as many as any president ought to serve, and so that established the 2-term tradition, which continued until Franklin D. Roosevelt ran for a 3rd term in 1940, and then for a 4th term in 1944, and died a few months into his 4th term. And by that time, there was pretty general agreement that maybe the original idea of the Founding Fathers of a 2-term limit was a good idea, and so they imposed that limit with the, I believe that was the 20th Amendment, anyway, an amendment to the Constitution in the early 1950s. Another check that we see in regard to Congress is that we're told that all bills to originate revenue have to originate not in the Senate, but in the House. Why in the House? Why not in the Senate? Anybody have an idea on that? Why they would put in a rule like that? Why can't either house? Yes, sir. Okay, so yes, you're correct on that. Senators were appointed by state legislatures up until the 17th Amendment, I believe it is. And anyway, so the significance of that is that the states are not paying taxes. People pay taxes. And so taxes should be originated by the House that represents the people, the House of Representatives. The origination clause, we call that, it was violated in the Obamacare Act. Well, they got around it on a very narrow technicality, but at any rate, it was an important clause to protect the right of the people against excessive taxation. Only the body that truly represents the people can originate taxes. You recall that had been one of the concerns of the Founding Fathers originally, that one of the reasons they said we are entitled to independence is that Parliament has been taxing us and has no authority to do so, because Parliament has authority only over areas in which Parliament has representatives. Now, in fairness to Parliament, I have to say that the Parliament had offered the American colonies representation in Parliament, but the colonies wisely refused because they knew that would compromise their legal case for independence. But anyway, so the idea of no taxation without representation was a basic principle that the framers used as a rallying cry in the War for Independence, and now they put it into the Constitution here. It goes really all the way back to the assizes of the 1300s, and even in principle back to the Magna Carta itself of 1215. But those are just a few of the checks that we see on Congress, checks on the president. But let's focus a little bit right now on checks on the judiciary. After all, we've seen that the judiciary was originally said by Alexander Hamilton in the Federalist Papers to be the least dangerous branch of government. By the way, how many of you have read the Federalist Papers? I'm glad to see a fair number of you have. I've encouraged you all to read it. When I was teaching at the law school in Montgomery, I would require my students to read the Federalist Papers. They would tell me that they were stimulating and thought-provoking, but some of them would say they were the most difficult things they'd had to read in their entire academic careers. And these are all college graduates. And I couldn't help taking the bait at that a little bit. Sometimes I'd say, well, you have to understand the Federalist Papers were written to get people to support the Constitution. They were written by John Jay and James Madison and Alexander Hamilton, but they were written to a very elite audience. They were written to the farmers of colonial America. And these farmers of colonial America were largely home educated, and so they could understand these things. Now, many of you, you've had 12 years of public education, and so that has imposed its limitations. And some of you have had your education further stunted by 4 years at a state university. But if you want to really study hard, you might be able to pull yourself up by the bootstraps and remotely approach the level of academic sophistication of the farmers of colonial America. And some of them could come close. But in the Federalist, Alexander Hamilton calls the judiciary the least dangerous branch of government. I don't know if he would say that if he saw it today. But what he said is that, look to the roles of the various branches. The Congress exercises will. That is, they determine the policy of the nation. The executive exercises force. He carries out the will of the nation as expressed through the legislature. But the judiciary only exercises judgment. All they do is simply interpret what Congress and the president have done and said. But Hamilton at that time assumed that the judiciary would be interpreting the Constitution and statutes according to the plain meaning of words, according to the strict intent of the framers who wrote those words, and didn't realize that as we move into the 1800s, as we saw some of the things that we've been talking about today here, transcendentalism and postmodernism and some of these things, that we would get away from the idea that words have fixed meanings. We would get to the idea that truth itself is a subjective thing. And if you have judges who think that truth is subjective or truth is whatever they want it to be in their own minds, well, that might be dangerous in drama, it might be dangerous in literature, it might be dangerous in comedy. But you can see how dangerous that could be in the mind of a judge. A judge who is entirely subjective is going to think it doesn't really matter whether the defendant objectively committed the crime or not. What matters is what social policy are we going to advance by a verdict of guilty or a verdict of innocent and the like. And so we start seeing courts get away from the plain meaning of the words of the Constitution. This starts in the late 1800s with ideas that we see developing at that time, the Theosophist movement, which is kind of an ancestor of the modern New Age, the idea that all truth is subjective and whatever people want it to be. And anyway, you start applying that to law, and it comes to mean that the plain words of the Constitution no longer govern. We have what we call, I'm sure most of you have heard this phrase, the living Constitution. It's an attractive phrase. Nobody except John Eidsmoe would want a dead Constitution. But what it means is a Constitution, the meaning of which changes with time. A good example of this was about 1961, a Supreme Court case, Furman versus Georgia, in which we have a man who is convicted of murder and sentenced to death. And the case goes to the Supreme Court. He is claiming that his constitutional rights have been violated. And the Supreme Court, in a 5-4 vote, says that, yes, capital punishment, as it was practiced here in this case, was a constitutional violation. Now, when I said it was a 5-4 vote, that's oversimplified. In fact, there were 9 separate opinions written in the case. And not only that, but each justice in each of his throughout each of their opinions had to tell which portions of each of the other 8 opinions they agreed with and disagreed with. So it's a mess. But anyway, 5 of them agreed for different reasons that capital punishment was unconstitutional. A couple said that it violates due process of law because the defendant didn't get an opportunity to present mitigating circumstances, and they might have a point there. Others said it violates equal protection because it affects minorities disproportionately. But 2 of them, Justice Brennan and Justice Thurgood Marshall, said that capital punishment today is unconstitutional in all circumstances because it is cruel and unusual punishment in violation of the 8th Amendment. Well, think about that a moment. Yes, the 8th Amendment does prohibit cruel and unusual punishment, but it doesn't say capital punishment is cruel and unusual, and it seems very unlikely that's what the framers meant, because capital punishment was almost universally accepted at that time, and at the same time they drafted the 8th Amendment, they also drafted the 5th Amendment, which twice expressly sanctions capital punishment. But Brennan and Marshall say in their concurring opinion, that doesn't matter. They say, use their words, the meaning of the amendment is not fixed and static. Rather, it must draw its meaning from the evolving standard of decency that marks the progress of a maturing society. In other words, even though capital punishment may have been acceptable by that primitive and barbaric standard of 1789, it is cruel and unusual by our humane and enlightened standards of today. But now, once we get away from the plain meaning of words as intended by those who use them, we're giving judges virtually absolute power. How many of you read Lewis Carroll, Alice in Wonderland, or Through the Looking Glass? Carroll seems to me to be kind of a precursor of the modern New Age or postmodern idea. But at one place there in Through the Looking Glass, there is an exchange between Alice and Humpty Dumpty. And anyway, Humpty Dumpty finally says, when I use a word, it means exactly what I want it to mean, nothing more and nothing less. And Alice says, Alice is a strict constructionist apparently, but Alice says, the question is, can you make words mean different things? And Humpty Dumpty answers, the question is, who is to be master? That is all. And he's right. If judges are free to make the words of the Constitution mean whatever they want them to mean, then judges have become our masters. And we are, in the words of one law professor, under a government by the majority vote of a 9-person committee of lawyers who are unelected and who hold office virtually for life. That's his description of the Supreme Court, and it is quite accurate. We see manifestations of that a little later when, in the Roe versus Wade decision, the Supreme Court suddenly decides that there is a right to abortion, even though the idea of abortion is nowhere mentioned in the Constitution, but as Justice Blackmun says in his opinion, that certain rights in the Bill of Rights have emanations that flow out of them. And these emanations form penumbras, or shadows or auras would be a good definition of that. In other words, he seems to have been issued a special set of glasses that when he reads the Constitution, he sees all these emanations flowing, and in the margins they apparently coalesce and form penumbras like abortion or same-sex marriage and the like. I can only say that this is extremely dangerous. The same court that can read into the Constitution rights that are not there can also read out of the Constitution rights that are there. Rights like free exercise of religion, or the right to keep and bear arms, or the right to make and enforce a contract, or the right to own and use property. And all of these have been subject to a great deal of limitation by certain members of the court. Anyway, so with this advent of the living Constitution approach, the need for strict construction becomes more apparent than ever. But also we need to be looking at what checks do we have on the judiciary? Well, there are some checks. For one thing, those who serve in the federal courts are nominated by the president and confirmed by a simple majority vote of not all Congress, but of the Senate. Congress has the power, according to Article 3, Section 2, to limit the court's appellate jurisdiction. For example, if we don't like the way the Supreme Court has ruled on 10 Commandments cases and terrible decision they made back in 1980, Stone versus Graham, we can simply have Congress pass a law that says the appellate jurisdiction of the Supreme Court over cases involving the 10 Commandments is hereby rescinded, and the court is out of the picture. Some say, well, that's interfering with the court. No, that is a check on the court that the Founding Fathers placed in the Constitution. And they wouldn't have placed it there had they not intended that we use it. Another is Congress controls the lower federal courts. If you read Article 3, you find that we read there at the beginning of Article 3 that the judicial power of the United States shall be vested in a Supreme Court and such inferior courts as Congress may establish. In other words, the Supreme Court is the only court that is established by the Constitution itself. Federal district courts, circuit courts of appeal, they're established by Congress, and they can be changed by Congress anytime Congress wants to. If Congress wants to put another level of appeals between the circuit courts and the Supreme Court, they could do that. If they want to abolish the circuit courts of appeals and say that all federal district court decisions must be appealed directly to the Supreme Court, they can do that. So Congress has the power to control the appellate courts. Also, Congress has the power to set up what the circuits are going to be. There are many of us who believe that the Ninth Circuit, which is California and Oregon and Washington and Alaska and Hawaii and Idaho and Nevada, it's the largest circuit, it's the most liberal circuit, it's also the circuit that is overruled or reversed more frequently than any other circuit by the U.S. Supreme Court. And if Congress wanted to do so, they could set up a new circuit and they could divide the Ninth Circuit into two circuits. There are a lot of people in Idaho, which is a conservative state, a lot of people there who don't want to be in the same circuit with California, and they'd like to see it divided in a certain way like that, but that's something that Congress has the power to do. Congress also controls the court's budget. If the Supreme Court issues a ruling Congress doesn't like, and then they submit a budget request to Congress for a new air conditioning system for the Supreme Court building, Congress can look at that and say, tabled. Or Congress, or the court also depends upon the president and the executive branch to enforce their orders. Andrew Jackson supposedly once said that John Marshall, he was the Chief Justice, John Marshall has made his order, now let's see John Marshall enforce it. Whether he actually said that, we don't know, but that certainly reflected his sentiments. By the way, Andrew Jackson also had a very interesting approach to judicial review. He said that, yes, maybe the courts can exercise judicial review, but they can't impose their view of the Constitution on other branches of government. Back in 1819, before he became president, in the case of McCulloch versus Maryland, the Supreme Court had ruled that a national bank was constitutional. That's a controversial ruling. But many didn't agree with it. In 1832, when Congress refunded the national bank and reestablished it again, Andrew Jackson vetoed the bill because he said a national bank is unconstitutional. And he said, oh yes, I know the Supreme Court said in McCulloch versus Maryland that it is constitutional, but I think they're wrong. And he said, each officer of the United States swears an oath that he will interpret and enforce the Constitution as he understands it and not as somebody else understands it. The court's interpretation of the Constitution is not binding on the president or Congress. any more than the president's interpretation of the Constitution is binding on the court. Well, today, that view would probably be laughed out of most courts, but I would say it has considerable validity. Also, we do have other powers. For example, how many justices does the Constitution say will be on the Supreme Court? Exactly, it does not say. That is established by federal statute by Congress. And so, if Congress wants to expand or contract the number of justices on the Supreme Court, Congress can do that. Franklin Roosevelt tried to do that back in the 1930s and seemed to receive considerable opposition from both parties, so he retracted the idea. There was a senator back in the 1980s, a very liberal senator, who considered a proposal there to expand the court, and he said, "This is a boneheaded idea." I'm talking about a Senator Joe Biden, who later, when he became president, seemed to think this might be a good idea. But I would have to agree with the earlier Biden and say that this could be a very dangerous thing. For example, let's say that Biden had expanded the court, as he wanted to do, made it up to, say, 13 justices, so now we have a 7-6 liberal majority on the court. First time Republicans take office, they're going to expand it to 17, and then 21, and who knows where. So this could be a very dangerous thing. Another is the power to impeach and remove justices from the Supreme Court. And yes, Congress does have that power. The House can impeach a justice by a simple majority, but impeaching does not mean removing. It then goes to the Senate, and the Senate can decide to remove or impose some other penalty, and there it has to be by a 2/3 vote. We've seen a number of federal district courts take some pretty extreme positions in ruling certain things that the president is doing unconstitutional. And I have to say that if those judges really think that the president is violating the Constitution, they perhaps have a duty to act, but I think they're wrong. The remedy for this is to overrule them. And many of those radical decisions have already been overruled or reversed by circuit courts or a couple by the U.S. Supreme Court. But as far as removing justices for their opinions, yes, many conservatives are advocating this. I have some reservations about it. First of all, what are the grounds for removing any federal official? Treason, bribery, or other high crimes and misdemeanors. It isn't treason. As far as we know, it isn't bribery. And while it may be silly, it probably doesn't constitute a high crime or a misdemeanor. But there is another ground for removing members of the judiciary that doesn't apply to other federal officers. That's where it says that they shall hold office during good behavior. And what is good behavior? Hard to say. It means the opposite of bad behavior, obviously. But what is the kind of bad behavior that would justify removing a federal judge when it wouldn't justify removing any other federal official? They probably put that phrase in there to make a stricter standard for judges, because judges are not being subject to re-election or reappointment, and therefore we need to have other means of removing them. But is writing a decision that I personally think is a horrible decision, is that really bad behavior? I doubt it. Especially if that judge really believed what he was saying. If a judge intentionally, knowingly violates his oath to uphold the Constitution, that might be a different matter, but I'm inclined to believe that most of these federal judges that are writing these crazy decisions actually believe in them. I have a saying that I said to a couple of you earlier: never attribute to malice anything that can be adequately explained by stupidity. And some of these decisions are stupid, but probably wouldn't give them much more than that. Second thing, As far as removing them, I think it's a waste of effort. I say a waste of effort because possibly you could get a majority of the House to impeach. Getting 2/3 of the Senate to remove them, that's just not going to happen. So it's a waste of time. And thirdly, it could set a bad precedent. Today, we could impeach and remove Justice Sotomayor for her leftist decisions. Tomorrow, the liberals in the Senate try to remove Justice Thomas or Justice Alito. In other words, it may set a bad precedent that I think is probably not a good idea. Ultimately, the best way to deal with judicial activists today is, first of all, have people in the Senate and people in the presidency who are going to appoint justices who believe in the Constitution. Secondly, to have law schools like the Oak Brook School of Law where I teach that are training justices. And by the way, if you're interested in Oak Brook, I'll have some material on it. This is a law school established for homeschool graduates primarily. And anyway, I'll have literature on my table tomorrow for you if any of you are interested in law school. And anyway, so those are some of the steps to take there. Support groups like the Federalist Society that now have chapters on nearly every law school campus in the nation. They were non-existent when I was in law school. But I think those are the steps to take rather than trying to go for impeachment and removal. Well, let's look at just a few other checks on government power. And we've seen the ones that are in the Constitution, but there are some others as well that are simply assumed. And one of these is the First Amendment itself. Now, the First Amendment, first thing we see is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The idea that church and state are to be different institutions doesn't mean that there's to be conflict between them. In fact, I would argue, as Luther and Calvin both did, that God established these two institutions, church and state, as divine institutions, and each of them has its special function given by God. The role of the church is to preach God's word and administer his sacraments. The role of the state is to preserve law and order, to protect human rights, and to keep the communists or other redcoats off the coast. And if the church is doing its job properly, if they are preaching the word, they're training people to be people of good character and good citizens. That makes it easier for the state to do its job of keeping law and order. If the state is doing its job properly, keeping the streets safe, that makes it easier for the church to preach the gospel. So church and state are to be separate. And I would argue that I think one of the real problems in our country sometimes is that we expect the state to do things that should belong to the church, and we expect the church to do things that should belong to the state. Intermingling these two in the wrong ways is a dangerous thing. But having church and state, powerful institutions, but separate institutions, that in itself is a check on government power. If government controls the church, then resistance to government becomes much more difficult. Likewise, free speech. The power of free speech, the right to say, I think what the president is doing is wrong, or I think what the senator is doing is wrong. That power of free speech is also a check on government power. So is freedom of the press. And if you're like me, you get very irritated at the press and some of the slant that they take on things. And yet I would rather have that than a press that is entirely controlled by the government. The fact that there are journalists out there, let's say if you have a judge who wants to act in an arbitrary or tyrannical way, the fact that there are journalists out there that are recording what is going on or are going to report about it, that is a check on any kind of government power and keeping it from becoming tyrannical. Private property, property in the hands of private individuals. There is another check on government power. The fact that you have some people who become very wealthy gives them the power to object to what government is doing. It gives them the power to organize, to raise funds, to print, to buy media time, to form organizations, and so on. So private property is in private hands. That means government power is limited, and it means people have the ability to use their private property in a way that checks the power of government. Still another, the power of nullification. Nothing in the Constitution prohibits nullification. In fact, you look to the 10th Amendment, the power is not delegated by the United States, or by the Constitution to the United States, that is, federal government, nor prohibited by it to the states, are reserved to the states respectively or to the people. Do the states have the power to nullify laws of the federal government? Nothing in the Constitution says that they don't. That being the case, that is a power that is reserved to the states. Nullification is a check on federal power. And one more, the Second Amendment, the right to keep and bear arms. Justice Joseph Story, in his commentaries on the Constitution, the most influential work on the Constitution from the 1800s, he writes that the Second Amendment is the palladium of our liberties. What is a palladium? Military terms? An outer wall of fortification. It's the outer wall of protection. How is the Second Amendment the palladium? Some have described the Second Amendment as the right that makes the enjoyment of all the other rights possible. In other words, one of the reasons for the right to keep and bear arms is so that citizens can resist not just foreign invasion or not just criminals coming on their property, but so that citizens organized together as the local militia can resist federal tyranny. Now, if that sounds radical, don't take that complaint up with me. Take it up with James Madison and Alexander Hamilton, both of whom say exactly that in the Federalist Papers. Someone once put it this way, that if I had a choice between the right to keep and bear arms or the right of free speech, I'd choose the right to keep and bear arms. And then I could say whatever I want because I have a gun. Or another way to put it, a congressman in Texas had a bumper sticker that he produced. The question was raised, which is more important, the right to life or the right to keep and bear arms? My response to that is, I may use my right to keep and bear arms in order to protect your right to life. But this congressman produced a bumper sticker that at the foundation I used to have on my doorpost. It said, if babies had guns, they wouldn't be aborted. So maybe that's the solution, that every baby be armed. And any abortion doctor has to wonder, could this kid be packing? Well, those are the things that I wanted to stress here today, that because of our biblical view of human nature, we know we need government power, but we also know that that power needs to be checked. And I hope what we've seen here shows that the Founding Fathers wisely placed some of those checks in our Constitution. I understand now that we're going to have a time of question and answer, and I think that's great because I have a lot of questions I want to ask you. And that's the way we do it in law school. The professors ask the questions and the students answer, but somehow I think that's not the way you plan to do it here. So I'll turn it back over to whoever's taking over.